Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefield of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. Today, we are going to talk about marijuana. And the title of the podcast says New Rules. Well, the reason the rules are new is not that the laws are new, but that they have come into effect in 2025, and there's starting to be more enforcement of them. So I'm going to talk about them. These are specific California laws. And under these laws, one of them is Assembly Bill 2188. The other is Senate Bill 700, both of which became effective on January 1, 2024, but did not impose obligations on employers until 2025. Now, under these two laws, employers generally are prohibited from discriminating against employees or job applicants for off-duty cannabis use. So we're not talking about marijuana use at work. We're not talking about coming into the workplace under the influence of marijuana. We're simply talking about ignoring applicant and employee marijuana use that is off-duty. So under these laws, employers cannot refuse to hire, they cannot fire, and they cannot penalize in any way an applicant or employee solely because of their off-duty, away from the workplace cannabis use, okay? Now, this has a couple of important implications. First of all, in terms of drug testing, all right? California, as you probably know, has a constitutional right to privacy in our California Constitution. So I'm not talking about the federal Constitution, which, as you may know, does not have a right to privacy. The Supreme Court created the right to privacy out of what they call the penumbras of the Fourth Amendment, which prohibits unreasonable searches and seizures, and some other provisions of the Bill of Rights, okay? And when you look at California law, we have something very specifically talking about the right to privacy. What that means is in California, when you talk about things like drug testing, there are limitations even outside of cannabis, okay? So many employers, for example, like to do random drug testing. Well, you can only do random drug testing if you have a safety-sensitive position, a position where if somebody's under the influence, they could actually harm another person or themselves. So not an office situation where the worst thing that can happen is they make the wrong number of copies, right? Their health and safety is not at risk. If they're driving, a regional transit bus under the influence, that could be a different situation. So when you have a safety-sensitive position, you can do random testing, but those are rare in California. So one of the things you have to think about with drug testing is, okay, for the most part in California, you're only going to be doing what we call reasonable suspicion testing. When something has happened, somebody is behaving a certain way, or something occurs, there's an incident at work that reasonably leads you to believe that person may have been under the influence of alcohol or drugs, and it doesn't have to be illegal drugs, remember. It could be something that was prescribed by a physician. I had an anxiety attack, 10 years ago, and I thought I was having a heart attack, so I went to Sutter, and they gave me this medicine that was the most unbelievable medicine. I never realized how people can live in the world without having anxiety, because when they gave me this medication, it was the most magical medication of getting rid of anxiety. But I could barely move. Like, I was super happy, but I couldn't move. So I cannot take that medicine, even if it's prescribed for me, which you should know, told them to write in my chart, never, ever give me that again. That is too good. Do not give that to me. I can't go to work under the influence of that medication. So even if it was prescribed to me legitimately, that is something that is going to affect my work performance. So I don't want you to think it's just illegal medication. That's not where we're going here. Okay, so by the way, the name of the medication was lorazepam. I just remembered it, and it was unbelievable. Okay, so anyway, what the cannabis law does now is say, okay, If you're going to do testing, whether it's random testing, pre-employment testing, and remember, random's only if you have a safety-sensitive position, or reasonable suspicion testing, you can only test for what we call psychoactive cannabis metabolites, okay? So you cannot use a urine test or a hair follicle test because that marijuana, that THC, could have been in that person's system for a while. It does not show anything about a current impairment, all right? It's going to show prior use, but of course, these laws, AB 2188 and SP 700, prohibit us from asking about prior cannabis use. So if you're going to do drug testing for cannabis, you have got to use a test that only looks for psychoactive cannabis metabolites. Guess what? Most drug testing facilities haven't figured this out, even though this rule has been in effect since January 1, 2025. So this whole year, we were supposed to be testing when we look at cannabis only for those psychoactive metabolites. Now, many employers have decided they're not going to test for marijuana at all. I get that. Seems easier. Let's not test for pot. Here's the problem. If somebody comes to work under the influence of marijuana and they get in an accident or they hurt somebody and they ask you, well, were you screening for marijuana use? Did you know this person was somebody who used marijuana every day? Well, no, we didn't screen for it. That can look like an unreasonable decision that you made, right? Because why weren't you screening for it? You used to screen for it. Then this new requirement came into play and you decided not to, or you've never screened for it and now you're certainly not going to do it because trying to find a testing facility that only uses tools that will look for psychoactive metabolites is too difficult, right? So I don't want you to immediately go to, I'm just not going to test. I want you to find a testing facility, if you're going to test for marijuana, that only looks for psychoactive cannabis metabolites. In our office, we don't do drug testing. We don't do anything dangerous, okay? We're in the office. We might be going to do an investigation interview. Everybody in our firm knows if they have an issue with some sort of addiction or anything like that, they need to reveal it. They need to come to us. They need to let us know what's going on. But I don't test. When you test, you get information that you have to take into account, right? And for me, in our workplace, it just doesn't make sense. But many of our clients, I think, legitimately want to do drug testing, and they should, based on the nature of their services and what their employees do. But you have to make sure that you're complying with all of these rules. Now, here's the bottom line. You can maintain a drug-free workplace. You can have a drug-free workplace policy, and you can prohibit employees from possessing cannabis, from being impaired by cannabis, or by using cannabis during your work hours or in the workplace, all right? You can also test for a current impairment that is caused by cannabis. So you can screen for THC, okay, which is the active psychoactive metabolite that will tell you that somebody has used marijuana recently enough or cannabis recently enough that they are impaired. So you can do a saliva test or you can do a breath test because those are going to be testing for recent use and potential impairment. And you can do that, remember, for pre-employment screening. You can do it for reasonable suspicion testing. You do need to make sure you train folks on reasonable suspicion if you're going to do reasonable suspicion testing. And there's a whole process in place where you want to make sure that you have at least 2 people who have observed the conduct that would lead to reasonable suspicion, but you can test for reasonable suspicion. And again, remember, if you have a safety-sensitive position, you can also do reasonable suspicion testing. Of course, you can also take action when there is a workplace impairment, when you determine that somebody has been impaired. Now, by the way, you don't have to drug test to figure that out. If somebody's stumbling along in the workplace with bloodshot eyes and, searching for a bag of Cheetos, I'm just kidding. This idea of being impaired, if it appears that they're impaired, you don't have to test. You can just say, I think you're violating our policy. It's more likely than not that you're under the influence, right? So I think sometimes we rely too heavily on testing. Now, I want to make sure you know that there are exceptions to AB 2188 and SB 700. First of all, if you're in the building or construction trade, you can still use regular drug testing methods like urine tests, and you can take action based on those results. And it's more likely in the building and construction trade that you're going to have a safety sensitive position as well. But you're not going to have to look for a testing facility that only is looking for those psychoactive metabolites. That won't be required if you're in the building and construction trades. Also, if you have positions that federal law requires employees in those roles be given background check investigations, security clearances, or federal level drug testing, like commercial truck drivers, for example, those roles are all going to be exempt from AB 2188 and SB 700. And then also, if you're a federal contractor and you're required to maintain a drug-free workplace to receive federal funding or grants, you're going to be exempt, okay? So when you look at these laws and you look at what's going on, one of the things I want you to think about is updating your policies and procedures. I want to make sure that you're not in a situation where you have old policies and procedures that don't reflect the new requirements. I also want to make sure that you understand that supervisors, just like we talked about last week with reasonable accommodations, supervisors and leaders need to be trained. They need to be trained to really spot real-time impairment, right? What's going on? What are you observing as a leader? What are you seeing in an individual, an applicant, or an employee? Also, keep in mind that in California, we have to balance privacy rights with workplace safety, right? So you have to think about the idea of, is it reasonable for me to be drug testing? If it is, do I want to be testing for marijuana? Do I care about cannabis? You want to think these through pretty carefully because there are some strategies you want to take into account. Also, just know that these are litigation risk areas. Plaintiffs' lawyers are already looking for violations of AB 2188 and SB 700. You cannot have on your employment application, for example, you can't ask about prior convictions for cannabis use. Remember, you cannot take into account lawful off-duty cannabis use. So unless somebody was convicted for something other than having a Prop 215 card or recreational marijuana that is lawful, you cannot take that into account in a background check. So there's a lot going on here in terms of cannabis. 3 things you need to do. You need to review your policies and procedures. Make sure that you are not, for example, saying in your policy you're prohibited from coming to work under the influence of illegal drugs, because marijuana is not illegal anymore. There are many purposes for which marijuana may be used. Now, they don't have a right to use it at work, and they don't have a right to come impaired. But if you limit yourself to unlawful drugs or illicit drugs, you're going to have a problem, okay? Number 2, if you do drug testing, I want you to examine your whole process. Who are you using for the drug testing? Are you testing for cannabis? Are you covered by an exception to these laws, AB 2188 and SB 700, or are you covered by them? If you're covered by them, do you have a testing facility where you are only testing for psychoactive metabolites? Have you trained your staff on reasonable suspicion? Do you have a reasonable suspicion policy, right? You want to make sure that you've really got your ducks in a row when it comes to drug testing. And the third thing I want you to do is really think strategically about your workplace. There may be certain divisions of your organization where drug testing makes more sense, right? There may be certain locations where drug testing makes more sense, and you can do that. You can decide to test in downtown LA, but not at Lake Tahoe because you feel like Lake Tahoe is smaller and you have a smaller group there and you're just not as worried about it. Or maybe they don't do as much manufacturing at the Lake Tahoe facility. So I want you to look at this strategically. I don't want you to just paint this with a broad brush. Take a look at your policies, take a look at your testing procedures, and really think about what will work for your organization. Because these laws do not prohibit you from taking action against somebody who is impaired at work. You just have to define it properly and make sure you're doing what you should be doing. Everyone, thank you so much for joining me today. These podcasts bring me a bunch of pleasure. I'm glad I get to share the time with you. If you have questions, comments, issues, concerns, or feedback, please let us know. You can email me at jshaw@shawlawgroup.com. Go out and have a great day, everyone, and do something nice for somebody. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.